Ready? Start. Reasons. In order to prove their case, the plaintiffs have examined plaintiff number 1 as PW number 1 by filing his affidavit of examination in chief at Exhibit 59. They closed oral evidence by filing pursuits at Exhibit 66. They have produced following documentary evidence. Para. The defendants have not adduced any oral evidence. They have submitted the documents below Exhibit 26. Para. As to issue number 1, in this suit, the defendants remained continuously absent for hearing. They failed to cross examine the plaintiff number 1. They failed to adduce oral evidence. They failed to argue. Therefore, I heard learned advocate for the plaintiff. He argued that the plaintiff number 1 and 2, being the legal heirs of original tenant deceased Rohidas, are in possession of the suit property. In the year 2012, they received the tenancy ownership certificate from the competent authority. The said certificate it is registered and mutation has been effected. Therefore, the plaintiffs are the lawful owners of the suit property. They are in lawful possession of the suit property, but the defendants number 1 and 2 brought into existence the sale deed which is void ab initio. He further argued that the defendants are causing obstruction and interference into the possession of plaintiff over the suit property. Hence, plaintiffs are entitled to perpetual injunction. Para. In this suit, the plaintiff number 1 has deposed and reiterated all the contentions in the plaint. He submitted that his father was tenant in the suit property. He had applied for tenancy ownership certificate. The purchase price was determined by competent authority, and thereafter the said price with interest has been deposited by the plaintiffs. Accordingly, the plaintiffs have received the tenancy ownership certificate. Therefore, they are in possession of the suit property. Para. In this suit, the defendants have taken an objection that this court has not jurisdiction to try and entertain the present suit. In this context, the provisions of Section 99 of the Hyderabad Tenancy and Agricultural Lands Act will come into play. Section 99 reads as under. Section 99 Bar of Jurisdiction. 1. Save as provided in this act, no civil court shall have jurisdiction to settle, decide, or deal with any question, including a question whether a person or was at any time in the past a tenant or protected tenant, and whether any such tenant or protected tenant is or should be deemed to be full owner of the lands which is by or under this act required to be settled, decided, or dealt with by the Tahsildar, tribunal, or collector, or by the commissioner or government. Second, no order of Tahsildar, tribunal, or collector, or the commissioner, or government made under this act shall be questioned in any civil or criminal court. Para. As per this provision, the civil court has no jurisdiction to determine who is the tenant. The questions which are required to be settled, decided or dealt with by tenancy court cannot be decided by the civil court. However, in the present suit, the material controversial issue is with regard to possession over the suit property. This court is not going to determine the status and character of plaintiffs as tenant. Whether the plaintiffs are in lawful possession of suit property is the material question. This question will not come under the purview of Section 99 of Hyderabad Tenancy and Agricultural Lands Act. Therefore, there is no substance in the objection raised by the defendants. Hence, this court has jurisdiction to try and entertain the present suit. Now, it is necessary to see whether the plaintiffs are in lawful possession of the suit property. The plaintiffs are coming before the court with the specific case that the father of plaintiff number 1 was the tenant. He was declared as protected tenant. The purchase price with interest has been deposited by the plaintiffs and the tenancy ownership certificate is issued in their favor. On the other hand, the defendants have come with the case that the defendant number 1 and his brothers were the joint owners of the suit property. They have also submitted that the brother of defendant number 1 effected partition of their properties and the suit property was allotted to the defendant number 1. They also submitted that the defendant number 1, being the owner of the suit property, has validly alienated it to the defendant number 2. They have denied the possession of the plaintiffs over the suit property. The entire oral evidence of plaintiffs remained unchallenged because the defendants have not cross-examined PW number 1 on perusal of tenancy ownership certificate issued in favor of present plaintiff number 1 and 2. It is seen that they have deposited the purchase price with interest. Accordingly, the tenancy ownership certificate is issued in favor of present plaintiffs. The revenue entries shows that the names of present plaintiffs are mutated in the 7-table extract wide mutation entry number 360.